Hello, welcome to week 3, where we're going to be discussing the theory and the application of what's called tort law. Now, tort law is going to encompass almost all aspects of the liability you're likely to face during your career and in your practice. Now, we're going to bifurcate tort law into two main categories. First, we're going to talk about intentional torts. These are torts that, as the name suggests, are intentional, acts that you meant to do. Things like battery, even though in the flight of passion, as some call it, may not feel intentional, we still have to draw a line in the sand when it comes to our laws and regulations and decide what we're going to consider as intentional, and then on the inverse of that, unintentional torts, or we're going to just kind of envelop that all within an umbrella called negligence. Like I said in the previous lectures, I want to be able to build upon snowball rolling down a hill type of thing. Build upon your previous knowledge and what we've learned in this class so you get a good rounded perspective of all of these subjects. Now, liability and negligence is probably outside of maybe the regulations dictating your decisions in your career is going to be the most impactful part of this course, and it's going to be ever present in a good practitioner's mind. So let's load up this slideshow and get started here. So today's lecture I've titled Torts and Liability, More Than Just Risky Food. To be honest, I didn't know what a tort was on my first day of law school. I knew I had a class coming up called Torts, but I wasn't quite sure what it was about. So if you don't know the terminology yet, that's why we're here. No worries. So quick introduction to this. Torts are simply defined as a wrongful act, something that's incorrect as our society has made rules according to. Tort law seeks to resolve disputes between a plaintiff and a defendant. Now, recall the differences between criminal law and civil law. Instead of a prosecutor, on the civil side, we have a plaintiff, someone that's been wronged. A word you could substitute in your head, though it wouldn't be proper outside of it, would be victim. Someone who's been a victim of a wrongful act, or an alleged victim of a wrongful act, because I know this isn't surprising to anyone. A lot of lawsuits are complete garbage. So plaintiff is seeking compensation from having suffered injuries or damages as a result of a wrongful conduct of others. A defendant, also known as a tortfeasor, is someone the plaintiff claims was responsible for the injury or damages. Now, remember when we talked about negligence, there were the four main elements: the duty of care, the breach of that duty, damages that were incurred, and a causational link, so that causal link that links all of them together. The tortfeasor is the person that breached their duty and had to be the causation of the damages. Now, unlike the burden of proof, which is beyond a reasonable doubt in criminal law, in civil law it is a preponderance of the evidence. Remember, it's just 51%. That's the minimum I've got to get to in order to prevail. Now, a tort can be, as I said, intentional, it can be negligent, and there is a third category called strict liability. Strict liability are acts that are just, we've made laws that said, if an injury has occurred as a result of X, well then it has to be strictly liable on one party. Certain things can't happen without that liability happening. What could examples of that be? We'll talk about that later on in this lecture. So an intentional tort, obviously, it requires intent. The defendant or the tortfeasor intended the consequences of an act. So punching someone in the face, when you do this, you are intending to inflict damage on that individual's face. Very rarely have I heard the argument, well, I punched them, but I didn't mean to hurt them. Now, I have heard in criminal court, I punched them, but I didn't mean to hurt them that badly. We have examples of people causing grievous, long-lasting injuries or even death from a fight. Now, that's clearly not, first-degree murder, but it is still battery. Battery is always intentional. The tortfeasor should have known, knew or should have known that certain consequences would result from the act. That's the overarching principle to understand of an intentional tort, that the tortfeasor knew or should have known. No reasonable person is going to punch someone else in the face without a reasonable knowledge that was going to inflict harm. Now, I think the only example I've come across where that has been disproven in court would involve a pillow fight between teenagers, when a battery charge in civil lawsuits, or excuse me, in civil court was brought up, and that case did not prevail, just because pillow fights are a little bit different. It's more akin to the theory of mutual combat. Several years ago, I don't know if I brought up this example yet in this course, but a good example of mutual combat that I found in the news was Zac Efron. Several years ago, he was in downtown Los Angeles after dark, which is just a terrible place to be after dark. And he was outside of a vehicle, and he got in a fight, I believe, with a homeless man. And neither of them were charged because it was mutual combat. They both got in each other's faces, and they both started fighting at the same time. It's hard to determine who's at fault for that. Criminally, at least. Civilly, that might be another question. And intentional torts don't just have to be against people. They can be against property, because property is owned by people. And so if you do damage to something I own, that's damage to me. So if you walk up to me, you pull my wallet out, you pull all the cash out of my wallet, you rip it into pieces, chew it up, and eat it, you have committed an intentional tort against my property. Or you might hear the term chattel. And if you cannot immediately replace that, then you're going to be liable for the damages. Here in the Pacific Northwest, we take torts against property pretty dang seriously. There's an area of law I actually practice called timber trespass. What that means is that if you damage someone's plants, their trees, of course, but their lawns, their bushes, their rose bushes, their garden, we don't just award damages. If you can prove intent, which just means anything above pure negligence. So even if it's a car crash, that's still intent because you were messing up while driving the car. You get what's called treble damages, or 3 times damages. So if you are shooting at thermite targets out in the woods, and as those ridiculously dumb things do, they blow up and cause fires. Even though on the package it says does not cause fires, that's moronic. They cause fires because we see them. I've involved in many lawsuits involving tannerite fires. And then that fire spreads and burns down my trees on my cabin property. Let's just, for the sake of argument, say my cabin wasn't touched, but my trees were burned. Now, trees carry value. They don't just carry actual financial economic value. They carry intrinsic value. Beautifying a property has worth and value. So let's say we go to trial and I prevail, and the jury says that my trees over my property were worth $50,000. Automatically, if they find any shred of intent, which does not require actual true, I mean to burn this down, mere recklessness counts as intent. You should have known blowing things up in the forest during a drought would cause a fire. Automatically, that $50,000 gets multiplied by 3. So I didn't just win $50,000. The jury actually gave me $150,000 due to treble damages in the Pacific Northwest, particularly in Oregon. So understand, intentional torts can really have some significant consequences if you don't know what you're talking about. An intentional tort against a person, let's talk about the 2 big ones, and then we'll talk about a third more minor one, but it does happen quite a bit. First is assault. Now, let's understand the difference between assault and battery, because we misuse the term a lot. In fact, law enforcement officers misuse the term all the time, and a lot of people don't get charged with things because cops wrote their reports incorrect. Now, an assault is not a touching. You can't assault someone by touching them. That's not assault. Assault is an intended act to cause apprehension or fear of an offensive contact. Now, I don't say harm, I say an offensive contact. Any contact that a person doesn't desire or shouldn't reasonably desire, we'll talk about that, is deemed offensive. Standing in line to get on It's a Small World at Disneyland and me bumping into people is not an offensive contact. However, if you're on the train, like I take the Max up to Beaverton, I take the Max and then I take the commuter rail from Wilsonville to Beaverton, and then Beaverton I take TriMet all the way into downtown towards Pioneer Square. If I'm on the train and I'm bumping against people, that's not offensive contact. But we've all seen it. If you've ridden public transit more than just a couple times, you've seen these creeps who do intentionally brush up against people. That is offensive contact. That is not necessarily an assault. What an assault is doing something to cause the apprehension. So the best example I have is to make a fist. If you are arguing with someone and you raise your hand up to strike, you've now assaulted them. You've caused fear that you're about to punch them in the face. I know all my examples are coming back to punching people in the face. In a recent book I read by Colin Jost, an SNL writer and actor, he brought up a thing he calls punch court. He thinks that punch court should be legal, that for minor disputes, a judge can rule that you're allowed to punch the other person in the face, and that's the end of the matter. I think punch court would be fantastic. But essentially, causing any apprehension. So if you are pretending to grab someone's butt to cause a harm or slap their butt as they walk by, even though you didn't intend to actually touch them, you were just going to tease around, you've actually assaulted someone. A lot of sexual assault doesn't require words and doesn't require contact. It just requires action. Now, build upon that in your mind. I know we have this arrested development in our personalities, a lot of, at least men do, where we haven't 15-year-old boys the rest of our lives at varying degrees. There are many actions that can be made that will be considered assault if someone is going to press the issue. And I'll tell you right now, the Me Too movement really brought about a wonderful revolution in stopping some of this pervasive behavior that is just disgusting. The firm I was at before the one I'm at currently here in downtown Portland, I was working down in Salem at a rather large plaintiffs firm, bills itself as the largest one in Oregon. That behavior was not just commonplace, it was expected and applauded. It was encouraged in a lot of instances, maybe not inside the workplace, but in extracurricular activities that were compulsory for that job. One of the main reasons why I left that job was that culture. And so any offensive contact that someone's going to be afraid of is an assault. Now, what happens when contact is made? Well, that's battery. So you always hear assault and battery. Well, there's a reason you hear both of them, because the second part is the actual contact. Now, battery doesn't have to be harmful. It only has to be offensive. A wonderful example I recall from law school, and that does happen in quite a few medical malpractice cases, involves people not consenting to procedures. And so as you conduct the initial procedures, you do taking vitals, whatever necessary examination you need to perform before treating or recommending certain plans to your clients and patients. You have to make sure you have consent for that touching. There are religious, not programs, but there are religious organizations out there, or beliefs, philosophies out there, that prevent certain people from touching other types of people. A common example is that from our Islam community, where in some of their practices, some of their adherents will not allow a man to touch a female, a male to touch a female in that culture if they're not married. Now that's a huge overgeneralization. I'm not trying to demonstrate an entire religious practice there. I'm just trying to give an illustrative example of what I'm talking about. There are cultures. There's the Hasidic Jewish culture. It's very similar prohibitions. It doesn't have to be religious. If a woman comes into a clinic and sees a male physician and says, "I don't want to be touched by a man," then that's all it requires. You don't have to consent to being touched. Now, if you're going into a doctor, you should probably have worked that out beforehand. But it doesn't really matter, because when it comes down to it, it doesn't matter if they're on the table. It doesn't matter if I'm sitting in my dentist chair, they've already numbed me, and the dentist is about to come in. If I go, "I don't want to be touched," they can't keep going. If I say no, no means no in medicine too. So it happens all the time. Another example that they had to get through in the courts several years ago was out of in New York City. I don't know which borough it was, but it was New York City. And a woman said, "I don't want to be touched by a man during this delivery. That's against my religious beliefs." And an emergency happened during it, and a man said, "Get out of my way." pushed through and started taking care of it, saved the woman's life and the baby's life, but it was still battery because they could have taken steps to not have a man touch her that were reasonable. Now, there are defenses to this. So the first is consent. So we talked about mutual combat and some pranks. Now, there are YouTube channels and now I guess that's a little dated, but there's also TikTok channels and Instagram reels where people have built careers. So I'm fighting off a sneeze here. Off of pranking people. And the deal is if people don't consent to a touching, you've committed battery. If people don't consent to certain actions, then it is technically assault. I love the videos of the man who dresses in a ghillie suit. He looks, actually I don't know if it's a man, so I'm going to say the person. The person dresses in a ghillie suit, which is a camouflage suit that has leaves and vines and branches sewn all over it, so they look like foliage. And they'll sit in a pot in a crowded area like in Las Vegas, some places in Europe, in a very crowded place, and as people walk by, they'll jump out and go, "Buh!" And it scares people. And some of the best videos are when scared people turn around and hit these people and get upset over it. That is technically assault. Now, whether it'll rise to the level of a lawsuit, I don't think it's going to be very successful because of what are the actual damages, unless someone's truly psychologically messed up or gets hurt. Then there's these other pranks that take it a step further. Some are called bait pranks, where some of these numbskulls they'll take a bicycle, they'll tie a very fine but strong rope to the back of it, and then they'll leave the bike at a high crime area, and then some poor transient person will come in and some person who's home insecure will come and grab the bike and steal it. And so they're preying upon this poverty cycle, which they think is hilarious, and they will take off on the bike and going downhill, and after about 50 feet, the rope reaches its end and they go flying and get hurt. These people have cases. They don't just have civil cases, they have criminal cases against these people. Now, they were in the act of theft, so that really gums up their ability to prosecute things, but they still have a case, and it's still wrong. Another one's where people will leave U-Haul trucks, moving trucks, open with fake boxes in the back, wait for people to jump inside to steal stuff, shut it, lock it, then drive around like crazy to scare them half to death. That is going to be all three. That's assault, that's battery, and that's our next thing, false imprisonment, which we'll talk about in just a minute. And so there is some consent. If you're going to go break a law, you're kind of consenting to some consequences, but there's no actual letter of the law other than it's technically battery, it's technically assault. They have a case. Whether they'll succeed with it, I doubt it. But it's there. Self-defense is another defense to assault and battery. If you can say that you were just acting in any form of self-defense, you have your own defense to that lawsuit. Now, what that may be, it almost goes back to mutual combat, or maybe even to the prank saying, well, they stole my property. That being said, and I want to get this across, I do this in every almost legal discussion I have with a new crowd, you can't kill people in defense of property. It's never legal. It's never legal. I grew up with the notion and understanding that was put to bed hard in law school. I'm going to put it to bed for you now if you believe this. I used to think that, now I grew up in the country, in the desert of eastern Utah, and people would say, well, if people come and harass your cattle, you're technically allowed to shoot at them. Or if someone breaks into your home, you're allowed to kill them. No. You cannot kill people for stealing your TV. Your dumb TV is not worth a life. A bad choice is not worth you ending it. However, if this person creates a reasonable fear for your life or your bodily protection, you may use lethal force to protect life. Now, if the person's coming at you with a screwdriver, yes, you can kill them. I really dislike this conversation, but it needs to be said. But if they're coming at you with a finger, you can't just kill them. You have to at least retreat. Now, there are states that say you can stand your ground. Dumb law, not going to work out for long. It's going to lead to way more ridiculous deaths and way more societal issues. So those stupid laws will go away. I know I'm taking a political position there, but deal with it. So there are states where you can stand your ground, but don't, because you'll lose in the civil courts. And I've said it before, and I'll keep saying it. People care way more for their money than they do for their freedom. People would rather do a year in prison or 2 or 5 years in prison than be bankrupt. It sounds crazy, but when it actually happens, that's what it comes down to. People get way more upset. Another defense is defense of others. It's self-defense is similar. You are allowed to defend other people. Now, if your neighbors are getting broken into, you can't run over into their house and start going Rambo, shooting the place up to get the bad guys. No, you call the police. If there is violence happening, you can intercede. Yes, that's the rule. I'm not going to get further into that. Now, the defense of property, you can remove people from your property, but I say take the Walmart approach. If you see someone, if you've ever seen someone in a grocery store or a supermarket or any type of retail establishment shoplifting, you see that the security guards aren't grabbing them by the shoulder and dragging them down and tackling them because they have a ham in their jacket. No, that's not what you can do. What Walmart does is saying, listen, would you please step into this office? We're going to call the police. A lot of people comply. But if they do try to manhandle you, I know that's a gender term, but they try to grab you and physically restrain you, they could open themselves up to a lot of civil lawsuits because someone's stealing, a 2-liter soda from a convenience store does not raise the level of, it's hard to explain, but just someone stealing something like that does not give rise to your ability to confine them. People still have the right to move around. And if you want to make what's called a citizen's arrest, you better have dang good reason to do it. Stopping someone from driving away from a scene of an accident, that can lead to a lot of civil lawsuits against you that you'll probably lose. As a defense attorney, I'm telling you, you're probably going to end up having to settle that. And your insurance is not going to be happy with you that you tried to take the law into your own hands. And what stinks about our system is sometimes bad people get away. But that's why insurance exists, and you need to understand the context better. So false imprisonment. That's the intent to confine or restrain someone somewhere which the plaintiff does not wish to be. If you don't have a legal right to keep someone somewhere, you can't do it. Teachers who keep their class after the school day ends, without actual procedure for like detention or something, that is technically false imprisonment. So that's the most mild example I like bringing up because I used to get annoyed at it all the time. But you can be guilty of false imprisonment for a lot of reasons. If your child is over the age of 18, you can't do anything to them. They are allowed to come and go as they please unless you have a conservatorship over them. Otherwise, you can't. We see false imprisonment against children all the time because they turn 18, they're seniors in high school, and the parents say, you're not allowed to go to the game tonight, or you can't go to prom. The kid goes anyway, and they lock him in the room. You technically can't lock your child in their room after they're 18. I don't know if I've never been locked in a room, but that's just the Cinderella example I like to bring up. From your profession, you can't tell a patient to stay somewhere and force them to be there unless you have a legal right to do that. Intentional tort against a person continued. Defamation. I'm currently involved in a defamation lawsuit that I'm representing a plaintiff in, my sister, against a sheriff's department back in Utah for some pretty messed up junk. And defamation's a real deal. And all defamation really takes is if you communicate, or in writing or in words or orally, something that you know to be false that would reasonably cause someone what's called public ridicule, you're guilty of defamation. And defamation, at least in Utah, I know, is a Class C misdemeanor. Here in Oregon, it is a crime as well. And it doesn't take a lot. In the social media age, a lot of people are guilty of defamation. Now, there are differences in who you can defame. The level of what's required, that standard of care is different. If it's against a public official, you're almost allowed to say almost whatever you want against a public official because they have a platform. They have reach to these people that they will listen to. So if I were to go out and say, this politician obviously spray tans and looks like a ridiculous idiot, I'm allowed to say it about that politician. That politician can't sue me for defamation because that politician could just go on the news and going, clearly I'm not spray tanning. I mean, look, and licks his finger and it smudges and goes, oh, sorry. That actually happened. But they have a platform in which to correct the misinformation. However, if the spray tan politician says something wrong about me, the person goes, well, Mr. Woodward eats babies. I really went to a dark place there, sorry. But let's say that this politician starts telling people that I am committing, horrendous atrocities against babies by eating them. They have defamed me because I don't have the platform. Now, I'm subject to scorn and ridicule to a group of people I can't correct the record with. So there's that difference. Now let's talk about something more realistic against each other. So a member of a community says something against another member of the community. Is it defamation? Well, yes. Even though they might have the same outreach to each other, we have to have a rule somewhere. And so if it's in writing, it's called slander, or it's called libel. So if you publish something online, that's libel. If you say it out loud, it's slander. Well, what if I post a video? Well, it's probably slander, but we just all group it under defamation. The defenses to defamation are privileged communications. If it was, if I'm writing to my doctor, defaming someone to my doctor, and that somehow leaks, it's not defamation because it's privileged. If there's no actual malice. If I truly believed my neighbor was eating puppies or something, that's something I truly believed, I don't actually have malice there, and so it's not defamation. If it's true, if my neighbor's actually cooking puppies and eating them, then it's not defamation because it's accurate. And then there's that public figure we talked about. Invasion of privacy is another big one. Now, in the Constitution, there is no outright expressed right to privacy. It doesn't exist. If you look at all the amendments, all the language of the Constitution, and all the scholars agree, there's no right to privacy in there. However, we have created what we call inferred areas of the Constitution. So under the Ninth Amendment, we have what's called the penumbra. Now, the penumbra is like this overshadowing, like halo. This thing that kind of is implied by the Ninth Amendment is our right to privacy. So things like using a person's identity, their name, their picture, or likeness for commercial purposes without their express permission. Catfishing is technically an invasion of privacy. If you go online, you steal my pictures to try to date someone else, that is invasion of privacy. Intrusion into someone's affairs or seclusions, disclosing private information about someone that a reasonable ordinary person would find objectionable. So if you're going to sit there and dox someone, or you're going to release private information about someone, you need to be really, really careful that this is not private information. So if someone has had an affair, or you think's had an affair, and you want to bring it up in an argument, understand that that person's going to find that objectionable, and if it's private, you have no right to explain it. Outside of like South Carolina and a few other southern states, affairs are not actionable things. In some states, though, like I said, in southern states, people do sue people who have affairs all the time, and it's okay over there. But that's just because their property laws still include women as property, and so the man can sue as a violation to his property. In more enlightened areas of law, we don't have that issue where affairs are consenting adults. Yeah, they stink, but there's nothing legally wrong with them. You do have a contract if you have like a prenuptial agreement. You have a contract with the person you're with, and if you violate that contract, there's consequences. But that's about it, because marriage is a contract. Then there's appropriation. That's closely related to the invasion of privacy, but it involves using someone's identity without their permission. So if you appropriate it, so if I go and I steal your identity and I start a blog or a podcast saying if I say I'm Joe Rogan, I'm appropriating his identity. It's not that common, really. Misrepresentations or fraud, and remember, these are all very closely related. But that involves the intentional deceit of another for gain. So here's what's required to prove fraud. A misrepresentation facts or conditions while knowing that they are false or with reckless disregard for the truth. A lot of financial crimes, a lot of Ponzi schemes are based on this. Having an intent to induce another to rely on the misrepresentation, that the other person has a justifiable reliance on that deceptive person, damages that are incurred as a result of that reliance, and a causal connection between the misrepresentation and the damages incurred. So you're seeing that the 4 elements of negligence are in there too. There's that duty of care, there's the breach, which is all that misrepresentation stuff, and then we have damages and causation. Very commonly happens in church settings. I'll go back to my experience in Utah, coming from a very predominantly LDS culture. Financial crimes are enormous across that culture because we have a hierarchical structure to their culture. Remember, LDS culture in Utah is so pervasive, it's actually culture. It's not just religion. If you leave that church, you are leaving your community, essentially. And so, of course, many cultures, it's that way. So where I grew up, certain people, let's say men of authority, are given a tremendous amount of respect and confidence and trust without any actual reason other than they are male and they are in position of authority in a God club, in a church, in a fraternity where we go and we believe in a certain way together. And these people will say, well, this person's investing in this business of his, maybe I should too. And this person comes out and says, oh yes, this is a great thing, you can trust me, wink wink, nod nod. And now we're seeing all sorts of people getting prosecuted all over rural communities, urban communities in Utah, all over the place this is happening. And so if you have any trust from a group and you use that trust to try to gain financially, you're going to really open yourself up to some fraud issues because people will believe you regardless. Another good one is the Kim Kardashian case. Shaq got called up in this a little bit too, but he got out of it. It was mostly Kim Kardashian and a few of her sisters several years ago, like 10, 15 years ago. Skechers came out with these shoes that were supposed to make your butt look great because they were all wonky looking. All they did was cause back pain. And so they did, obviously, scientists and consumer groups did studies on these. Turns out it was fake. But the Kardashian sisters had promoted this as something that was working. Now, why is this fraud on their part? Why did they get sued and have to pay a settlement for this? Because they have those features in abundance that the shoes were trying to develop, I guess. I don't know a better word for it. We're trying to create in people. So people say, oh, if I want to look like this person, I must wear these shoes. And that's fraud. Even though Kim and her sisters did not develop the product, all they did was appear in an advertisement for them. It was enough. Another was those bracelets that were supposed to magnetize your blood or something and make you have better balance. Complete garbage, or complete rubbish, proven before the product even came out. The Kardashians got in trouble for it. Shaq got in trouble for it. I think Phil Mickelson might have gotten in trouble for it. Our athletes just aren't smart individuals. They just are good at sports. Some of them are smart. I watched Jeremy Lin give a speech several years ago, a basketball player, and he was quite brilliant. But in general, let's understand fraud can happen a lot. And if you're going to do social media stuff, you need to be really, really careful from what you put out there. I used to show a lot more examples, but I get in trouble sometimes because sometimes people know the person I'm pulling up as an example. But if you are going to express these Dr. Ozian type things, he's protected because he has a huge tort insurance liability thing and a lot of law firms to protect him. You don't have that. So if you're going to go out and say complete nonsense about Crohn's disease and that it can be cured by sticking Q-tips up your nose or something equally, absurd, you're going to get dinged with some fraud lawsuits. Wrongful interference, that's usually things like contractual relationships. So if there's, two parties that are engaged in a legal contractual relationship and you go on and try to mess with that, wrongful interference can be a big problem. It's more common in the business industry. If you have a contract with like a hospital to contract your services and there's someone trying to get that contract out from underneath you, there are correct ways to go about that, but a lot of times people violate that and cross over. Trespass is another one. So they can be trespass to your land, to your chattel, your possessions, or conversion. So trespass to land, you're on my property. Chattel, you have, borrowed my iPad even though you're going to bring it back. That's still a trespass. And conversion was that you took my iPad and you sold it. You converted it into money for yourself. The problem with that is if you stole my iPad and you sold it to someone, I couldn't get my iPad back. That iPad's gone. It's been converted. That person who bought it has done nothing really wrong if they did it the correct way. So when things get bought on like the marketplace on Facebook or Meta, whatever they're calling it this week, once it's converted, it's gone. Very rare cases do you get your stuff back. You just get the value of it back, the money it's worth, intrinsic value included. And then there's intentional infliction of emotional distress. Do I have negligent in there? No. So intentional infliction of emotional distress is when you are doing something that's considered outrageous. When you're bullying someone, when you're picking on someone, that can intentionally inflict emotional distress on them. Negligence. So we've been over these real quick again. There's the duty, the breach, damages, causation. Pause the slide, burn that into your memory again. It all really boils down to the concept of reasonableness. Ask yourself, is this something a reasonable person in this instance would do? Going back to that, I love the quote from The Office. Dwight says, the best advice that Michael ever gave him was, don't be an idiot. Whenever he does something, he always asks himself, would an idiot do this? And if the answer is yes, I do not do that thing. Oh, man, that is lawyer advice numero uno right there. That is fantastic advice. If a reasonable person wouldn't do this, don't do it. Strict liability. It considers more than just fault. So here's an example. Things called abnormally dangerous activities. They involve a high degree of risk, commonly performed in communities or areas, and carries potential for harm or serious nature to a person or property. If my job is to dynamite quarries, I am engaging in an abnormally dangerous activity. That is a defense to strict liability. I know what I'm doing is dangerous. If I go climb El Capitan down in Yosemite and I fall to my death, I don't get to sue the National Park Service. They didn't put that rock there. In fact, they are allowing me to climb it technically, but you assume the risk because it's abnormally dangerous activities. That's why you see people who die in skydiving accidents don't really get to sue anyone because you're jumping out of a freaking airplane. You kind of thrown caution to the wind by jumping. Yes, you got a parachute. Whoop-de-freaking do. It doesn't matter. It's like wearing skydiving's the same as wearing a bulletproof vest and telling your friend to shoot you. You're probably going to survive, but there's a good chance you're not going to survive. And that's a risk we legally allow you to take. Now the shooting one, I don't actually know if it's legal. I don't think it is. I think it's always illegal to discharge a firearm at someone, but don't quote me on that. But it is legal to jump out of an airplane. I don't know why people do it, but you people do it, and that's okay. But understand, you don't get a lawsuit if you Peggy Hill slam into the ground and somehow survive there. Negligence per se is very common to hear in lawsuits, and that's a negligent act whose duty of care is already established by law, and that law was created to prevent the type of harm to the type of person it concerns. Case in point, crosswalks. If you mow over someone in a crosswalk, negligence is already established. You can't run someone over in a crosswalk without you being negligent, because it's your duty. It's presumed. You are supposed to know when a crosswalk is coming up. You're supposed to know that it's there. It doesn't matter if you've never been in that city before. It's not their fault. You're supposed to know the layout of the city and their streets before you go there. It's not their fault if you're new. So if you're pulling up and there's a crosswalk and you mow someone over there, you are strictly liable. That is negligence per se. The law was created to stop cars from mowing over people, and the class people to be protected are pedestrians. There are negligence per se areas everywhere. Product liability. This is a big one for you, especially if you're going to be giving anything like supplements or nutritional advice here. It's based on negligence or misrepresentation or fraud. The example is when a manufacturer makes a product that is unreasonably dangerous to the consumer. Remember to consider reasonableness in this analysis. A defective front seat airbag injures or kills a small child is not sufficient, as the child is not supposed to be in the front seat. Another one, herbal or vitamin supplements marketed as treatment for diseases without evidence or data. If someone comes to you saying, I have colon cancer and I'm going to go get my treatment, or whatever you say to do, and you say, well, I want you to go out and stare at the sun for 6 hours every day and you'll be healed. That is not product liability. So let's make a product saying, listen, take this product. So let's say essence of sunlight in this chapstick. I've infused this chapstick with sunlight. There's crazier claims out there. And that if you use it, your cancer will be gone. If you manufacture this product, that's product liability because it's based on misrepresentation or fraud. Sometimes it may seem like product liability, but it's not. An example that actually happened in some cases were lighters, little Bic type lighters, where one actually malfunctioned and hurt a child. Well, there was no liability there because those things aren't designed for children to use. That's just as simple as it gets. A child should not be using a Bic lighter. That being said, sometimes firearms discharge in homes due to children tragically getting a hold of them. The manufacturer of the gun can't necessarily be held liable for that because children aren't supposed to have firearms. I'll argue a great deal of adults shouldn't have them either. I don't know if anyone would argue with that. We all know someone who owns guns that shouldn't own guns. And that's not a Second Amendment argument. That's just reality. Under strict liability for products, we have things like defective products. So if I'm using a Bic lighter and it explodes, well, it's defective and I have a suit. A design defect, if my chapstick lid, if I pulled this off and it's shattered in pieces and then cut me to pieces, then there's a design defect because they designed it incorrectly. And warning defects. Now, people used to bring up the warning on cups of coffee at McDonald's. That is a warning defect because McDonald's created an enormous risk by putting their coffee beyond boiling temperature. I mean, well beyond, almost beyond boiling temperature. I was thinking the Celsius, so I don't think it was at full boiling temperature, but it was far too hot. You need to adequately warn people. You see the signs, wet floor, piso mojado. If you see those on the ground, you need to understand they're warning you for a reason. There's a problem there, and there's a lawsuit. If you see a warning, it's because there was a lawsuit. There's defenses, things like known risk. If everyone knows that this section of sidewalk gets flooded every single year and turns into an ice skating rink, that's kind of a known risk. The city does have a duty to cure it, but a known risk is a known risk. There's assumption of the risk, or that comparative fault we talked about. Assumption of the risk is jumping out of an airplane. If your parachute doesn't open, you can't really sue the person who packed the parachute or designed the parachute because you're jumping out of an airplane, people. We can only make laws so far. And if you choose to jump out of an airplane or get into a cage and go into the water and let great whites swim around you, and one happens to get its beak between the cage and rip it open and eat your leg, you don't have a lawsuit because you went swimming with sharks. Ah! These things, you assume the risk. Another one I've seen actually prevail is, and I don't know if I'm happy I used this argument, but it worked, was that my client was the defendant in a lawsuit where his passengers got hurt in an accident when they were out muddying out in the country. And I said, listen, this is the question. This is the line of question I asked. Let's change some names. I said, listen, Jim, did you know Bob to be a good driver or a bad driver before you guys went out? Bob's my client. Jim's one of the plaintiffs. And Jim said, oh, everyone knew Bob was crazy. Bob's the worst driver we know. I went, but you still got in the car with him? Well, yeah. I said, if he's the worst driver you know, why would you get into a vehicle with him where you were going somewhere where you were going to be crashing into stuff? And he went, well, we wanted to have fun. I went, then you've waived your right to expectations of safety. Because fun, often, I'll be admitted right now, a lot of times fun involves things that aren't safe. I'm in my mid-30s, and I'm still, every time I see my dad a couple times a year, whether he comes out here or I go out there, and I always reveal one or two news stories to my father about dumb junk I did as a kid that should have gotten me killed or other people killed. And he just rolls his eyes, goes, oh, I did that stuff too. And so, man, we assume some risk. And then misuse. If I am, I buy this chapstick and I go, you know what? I'm going to start eating chapstick. and I start eating chapstick, and it forms this giant bezoar in my stomach and plugs my duodenum, or duodenum, as lame people call it, plugs my duodenum, and I develop sepsis somehow from this. I don't know the medicine. I'm a lawyer. I'm not that kind of doctor. I can't sue the chapstick company for product liability because I ate something I was supposed to just put on my lips. So here's a hypothetical to wrap us up. This will be part of your assignment. So Dr. Revan and his protege, Dr. Malik, shout out to Knights of the Old Republic and Star Wars, are former engineering professors who started their own speedboat manufacturing business. During production, Dr. Malik discovers that there is a slight issue with the throttle in many of the models and decides to remedy the issue by placing a warning in the owner's manual. He does not tell Dr. Revan. As business begins to pick up, Dr. Malik begins to grow frustrated with his lack of compensation and storms off to begin his own speedboat company. I'm really ripping off Star Wars here, sorry. To help his new business, Dr. Malik buys multiple advertisements on social media platforms that promote his latest model of boat while lambasting Dr. Revan as unsafe and likely to get you killed. A few months later, a customer driving a Revan model crashes into a pier as a result of a sticky throttle. Questions. What torts have been committed? Identify the party and what the tort is. And what defenses may there be to these allegations? So that's what you need to understand. That's what you need to ferret out yourself. Go through the hypothetical. Identify who the plaintiff here might be. Who is the person, the tortfeasor, the person, the victim, quote unquote there. There might be one. Look at this. See who was wronged here. Then look at all the defenses to what might have been wrong. And those are your first two steps. Who was hurt here? Figure out what was going on. Now, under what, how were they hurt? So was this strict liability? Was this negligence? Was this intentional? What are we dealing with here? And then what are the defenses to that? Go back. The lecture's right there. I show you the name of it, and the defenses are listed. List them out for me. Then answer that second question. So that is a second question. What defenses might there be? It's only a handful of sentences here. This is rather simple, but reach out to me if you have any questions or insights or creative solutions. I love creative solutions. But that's going to be it for this week. So, review this, understand what intentional torts are, understand negligence again, and understand the products issues. The products issues, I'm going to go out on a limb and say are going to affect people in nutrition and medicine a lot more than other areas, just because there's a lot of products you've got to convey. And if you recommend a product to someone that turns out to be defective in some way, you're going to get looped into this because you are the expert. You're expected to understand the product. And if they take the product based on your recommendation, because you're recommending it, you're absorbing some of the liability. Same with references. Understand how job references go. I have numerous people come to me for job reference. Not numerous. I'm not that popular. No one cares what I think. But I have had several people. I remember after I just graduated from law school, several of the undergrad students that were like freshmen and sophomores when I was a senior in undergrad, I was the editor-in-chief of my university's newspaper for 2 years. So I oversaw a lot of younger students that were highly ambitious. So when these students were getting ready to graduate after I just finished law school, they were saying, hey, can you write me a letter of recommendation to get into law school or medical school or pharmacy school or any other issues? Issues, I call them issues because you're in grad school, you understand. And not all of them I was willing to do. I was not willing to stake my name, my reputation on their on their accomplishments. And that's the same thing with the products you're going to recommend to people. So in general, physicians don't usually share in some of that responsibility if Pfizer messed up. Some of the people I think that have been left out of this major litigation over opioid use are the doctors who prescribe them. I think they're equally at fault for this. And they should all be sued in this as well, but that's a lot of people. But you need to really recognize your exposure here if you're going to recommend a product. And if that product is not through science, you need to remember what science is. If there's not evidence to show that this is going to do what it says it does, if this is not FDA evaluated, I wouldn't recommend it at all. I think it's way too dangerous to do. outside of maybe just a supplement. So like, let's go with our normal allopathic or whatever treatment, but here's the additional stuff here that I've seen in my anecdotal experience to work. You are obviously absorbing a lot of that liability, but you're rational thinkers and you're out to do good. I don't know any of you out here that, of course, I haven't met any of you individually yet, but I don't think any of you are sitting there going, chortling in the back, wanting to hurt people. And so just keep all this in context, looking at everything else, so thinking, all right, is this unwanted? Could this be exposure, open me up to any liability? Make all of your professional decisions carefully. And your personal decisions might bleed into this as well. You're in a doctorate program. People are going to see you and interact with you and see your title and give you respect just by virtue of that piece of paper we hang on our wall. I don't necessarily disagree with that. I think that might be actually a good thing, seeing people have training and experience. However, that reliance is going to open you up. And so if you have questions about a product or whether to recommend something, call an attorney. Call me. I will gladly walk you through this as a favor. It's really not that difficult to avoid liability if you're truly cautious in your private life. And in your personal life, going back on that topic, I actually just tangented off of recommending stuff in your private channels. People are still going to assume comes from good sources. So you've limited yourself by your degree. You are no longer allowed to have freewheeling opinions on stuff without also accepting the enormous liability that comes out. I call it the Dr. Oz effect. If people really wanted to push it, and they have, he has been sued and lost. He's settled. He does, the rich people do is they settle because they have the ability to do that. That's the problem. And so you've now educated yourself to a level that people will give you. They'll defer to your experience even in personal settings. So be careful. Be super duper careful. And otherwise, leave a tort-free life. So move on with this assignment. I'll get your feedback. We'll go from there. Thanks.